Good morning. I think everyone who is in the cybersecurity career field may get some benefit from this. I'm going to talk about cybersecurity and the law. For many people, you may think, well, that just involves lawyers, but honestly, because you see and interact with and touch data, this is very important for you, especially if you're in career fields that involve things like forensics or compliance or actual criminal investigations. So I thought I would share some information from me, my own experience, as well as some information that I've pulled up from, some of my certification exams and such that I've worked with. They all talk about some of these things, but I wanted to give kind of a more comprehensive view. So we're going to talk about cybersecurity and the law. Oh, and first and foremost, before we go any farther, it's important for everyone to realize that I am not a lawyer. My disclaimer, my legal disclaimer is I'm not a lawyer and I'm not giving you legal advice. The reason for that is there are people out there who will take information and say, this, my mentor told me to do this, and they go out and they do something wrong and they blame it on me or you or whoever, the source of the information. None of this information is, except for my war story, none of this information is sourced by me. It's all information I found out over the internet and through my study guides, etc. So, please realize that I'm not giving legal advice here. That's my legal disclaimer. Okay, so let's talk about EULAs. Does anybody know what EULAs are? E-U-L-A, and what it stands for? Thoughts? Okay, a EULA is an end user license agreement. And we're going to see this in the next slide, but what's the big deal about EULAs? And what is something we all agree about end user license agreements? What we can agree on, nobody reads them. That's exactly right. That's the scary thing about it, because I'm going to go to the next page. It is a known artifact of a legal agreement. In other words, if Microsoft says in their end user license agreement, when you first install Windows 11, let's say, or Microsoft 365 or whatever, yeah, let's use Microsoft 365 because of the SharePoint vulnerability. In the end user license agreement for Microsoft 365, it probably says if there's some problem in our software or services and it causes you to lose data or confidential information or something, you can't sue us. It may say that in the end user license agreement. The thing that we have to remember as consumers is that the license agreement is a legal contract, and it has stood up in court. It's, many times, I won't say 100% of the time, but it basically says, here's what you can expect, here's what you can't expect, here's what we certify we are going to provide to you, here are things that we will not provide to you, etc. So it sets expectations and it sets limits to liability. In other words, if you're working, on a let's say a massive project for the President of the United States, and your Microsoft Word gets corrupted and you can't go get it, you can't sue Microsoft because Microsoft Word got corrupted. It says that in the end user license agreement, I'm presuming, because like everybody else. I didn't read it. So my suggestion to everyone is the first time you see an end user license agreement, take the time to examine it. The good news is these days they've broken it down into various things where it says user's responsibility, expectation of privacy, limitation of liability, those sorts of things. So they've sort of put things into areas where you should take a look at each one of them, but realize that it is a legal contract and it has stood up in court before. You need to know what your limits are and what the expectations are. And that document tells you that, but like Easy pointed out, we don't read them, which is sad. We're the ones that need to be protected. Okay, log on warning messages. Here are a couple of them. I realize the screen is kind of small, but I think you get the point. The log on warning messages, we used to call them banners, but it is something that comes up as you are first connecting into a session. In other words, when you first log on to Windows, or when you first connect into a Department of, Defense online system or something like that, they're required to put up something that says use of this system implies your consent to the following terms. And so, these are two that I just pulled off the internet. There's nothing special about them. But the end user license agreement is for the use of a particular software product, usually, or service, and then the log-on warning messages are each time you connect, and that's the difference between the two. Okay, the log-on warning messages are as you enter a new system. This time you logged out, logged back in, this thing will pop up. And I have some information about what is typical in a log-on warning message. It says it's for authorized use only. In other words, you've got to use it for the purpose in which it was designed, and only people who are authorized to use this should use this. Your activities may be monitored. Now, a lot of people get confused with that because they say, I've got a right to privacy. Well, yes. The difference is that for online systems or software or services, the provider also bears a responsibility to, usually to the best of their abilities, to make sure that someone is not misusing their software or service. In other words, I'm going to use an example. You go to your local grocery store, and you log into their public Wi-Fi, and then you sit off in their lunchroom connected to their public Wi-Fi, and you go in and try and hack the Pentagon. The system is supposed to have monitoring on it, which would prevent you from doing that. And so therefore, in their system, they monitor for, let's say somebody tries to go, to sites that are considered to be questionable or downright illegal, and they block those. So some people say, well, it's my right to access. Well, actually, no. The provider is saving themselves from legal actions by preventing you from using their system doing illegal things. So, and in order to find that out, they've got to monitor to see what you're doing. Maybe not specifically what you're typing, but where you're going, what data you're uploading and downloading, etc. All of those can and are monitored. So that's number two. Your activity may be monitored, and it's for their protection. Number three, the consequences of violating the policy. If you get caught violating the policy, you could be subject to disciplinary action. You could be subject to removal from and banning from this system. And if it's bad enough, you could be subject to us turning your information over to legal authorities for them to come and put you in jail. That's, if you read those log-on warning messages, they frequently say, you know, for penalties up to and including legal activities, which means they turn you over to a lawyer. And then number 4, you have no expectation of privacy on the system. No expectation of privacy because it's their system and you're basically using their system, okay? And you're not allowed to use their system for illegal things or unethical or immoral things. You know, you can't go out and set up a predator's website or something. No, you are not allowed to do those things, and it's their responsibility to prevent you from doing it. So, no expectation of privacy on these online systems, contrary to what you may think. Any questions before we go on? Okay. Let's talk about legal rights. Legal rights. And some of them, some of these things are good to know, but all of them are things that you must be aware of if you're going to be in a cybersecurity career field. And I'll talk about this a little bit. For example, you say, do I have right to my emails? Are you allowed to monitor my emails? And in most cases, the system monitors emails to make sure you're not performing any illegal activity, but your boss, for example, is not allowed to see your emails. I've had this occur. I was an exchange administrator a million years ago, and I've actually had supervisors and managers walk into the office or call me on the phone or send me an email that says, I need to find the email that Tom sent to Jane last Tuesday. I can't provide that. What? I just told you, you must provide that. Even if it comes down to my boss telling me that, the legal limits are not only what I'm allowed to review, but what I'm allowed to disclose and divulge. There are very strict limits to that through the law. So if going back to that end user logon, it says things like in investigations or criminal investigations or something like that, if somebody comes up to you and says, you know, here's my law enforcement badge, here's the case number that we're investigating, we need this information, you say, put it in writing. They put it in writing. Okay, here's the information. Exactly what they ask for. No more, no less. Because it is part of a criminal investigation. So that's the difference. A boss saying, you know, I want to find out what this person's doing. The expectation there, it is not, they aren't allowed to ask for it, and you, being the person that is custodian of the data, aren't allowed to divulge it unless there are very specific procedures. In every case, what I recommend you do is make sure you speak to your management before you turn any data over or make data available for anyone to see. Go to your management and make sure that you're following the right procedures. So we're going to talk about legal hold, right to privacy, FOIA, admissibility, and chain of custody. So I'm going to try and go through these kind of quickly. A legal hold is very important for you to know, because let's say you are holding on to, let's say somebody, you know, left the organization, and you as the IT organization or the cybersecurity group are preserving this person's laptop contents. And then all of a sudden somebody says, oops, this laptop may have been used in the commission of a crime. A legal hold means you must preserve any possible evidence that may be contained on that laptop. In other words, if your procedures call for you to wipe the laptop, you're not allowed to wipe the laptop. If your procedures call for you to back up the data to the cloud, you're not allowed to back up the data to the cloud. In other words, a hold means, and I'm going to use my iPad mini here as an example, it means you hold on to it. Wherever you're at in the process, stop. Get a hold of this, make sure it's secured, and do not let anyone else touch it. All right? And the reason for that, I'll talk about this in a little while, it's called chain of custody and admissibility. And that is my war story that I'll give at the end of this. Kind of gruesome, but I'll share about it. But if it's going to be used as evidence, it has to be preserved. So if you have backups, don't back it up. If you delete logs, don't delete logs. A legal hold means stop. Make sure that this is preserved. Everything that you've done up to this point, stop doing it. Hold on to it and wait for further instructions, okay? So a legal hold is based on a current or an expected legal action, like an investigation pursuant to a court case or criminal investigation, right? That's a legal hold. Your right to privacy. Remember that those logon warning banners or the end user license agreements, they usually say in it, you should not presume that whatever you're doing in our system is private. Because if you're doing something against the law, they're required to stop you and prevent you from doing so. That's them saying, we have to monitor you so we don't end up in jail. All right? That's the right to privacy extends only in certain areas like email content. And again, email content, it only is private until there is some sort of investigation. And an investigation can't be conducted by unapproved people, like your boss or your division chief. Nope. They have to call the police, or they have to call, actual legal investigators, etc. And they have to do things just like going into your house. To go into your house, they have to have something signed by a judge. We all know what it is. It's called a search warrant, and it says this person is allowed to go into this house and look for these things. And some of those things could be very blurry. Anything related to, anything that may have those sorts of things. So the same thing occurs to electronic data. It's like your electronic house, but there are legal ways that somebody in an investigative authority can enter and search. Okay? Just something for you to know. There is no right to privacy on online systems. And like I said, it has to follow very strict guidelines. Very strict guidelines. And by the way, you don't determine those guidelines, and your boss doesn't determine those guidelines. The law determines the guidelines. Again, I've had people come up and say, I need this email. And I said, it has to come from a police officer, the request. And I will need their investigation number for my notes. Okay, so next one, FOIA. Many of you may have heard of FOIA. It's Freedom of Information Act. It's a big thing in the U.S., and it basically says anything that the federal government or state governments generate in the form of communications or documents or artifacts or whatever can be requested by members of the public. Why? Because these people are public servants. They're performing data to support and service the customers, which is the public. So you can, under the right circumstances, for example, request copies of emails. Remember I said investigations. This is a FOIA request, can request emails, but again, it has to be very specific. I helped to write the FOIA process for the Secretary of Defense back in the early 2000s as a result of their FOIA program. It was 52 pages in length, and it said, if this, then this, click this, move this, copy this, etc. And it was line by line by line by line, 52 pages of absolute golden goodness on how an IT person could adhere to the law and yet still provide FOIA information in response to FOIA requests. And anyone in the public can make a FOIA request, supposedly anyone. So I'll give some examples. My wife and I like to watch YouTube videos of crime stuff that goes on, and like court cases. So you can actually say, well, you know, here was this person who they're charging him with, oh, I don't know, driving without a license. And he says, well, I submitted a FOIA request to the sheriff's office to get copies of their badge cams. You can legally do that. And you don't have to have an interest in what, you know, even if they didn't pull you over, you can request the badge cams, because the badge cams are there as a public service that you as a tax-paying public member help to pay for. So you can request badge cam videos from, you know, a certain officer at a certain time. You know, you can request those. For example, a FOIA request, Freedom of Information Act, and the government, and that's usually state and federal government, must provide that unless there's some extremely extenuating circumstances. And so that's FOIA. Why do you need to know that? Because the information that you're working with could be subject to a FOIA request. So now you've got a legal request, like for an investigation, or a FOIA request that comes in from a member of the public. Both of those would require you, if you have custodian of the data, require you to supply that data. Okay. Admissibility. This is a big one. Have any of you heard about admissibility, like in court cases? Somebody says, well, that's non-admissible. If something is admissible, it has to be proven that it is authentic. You know, that is indeed the pen that President Roosevelt used to sign this law into action or whatever. How do you prove it? It looks like his pen, but how do you prove that it was indeed his pen? And I'm using the pen as an example. It could be, you know, prove that that was his phone. Prove that that was his phone. Or prove that that was the phone that you recovered from the crime scene. How do you do that? You know, admissibility, if you can't prove it, it's not admissible. It's not allowed to be used in evidence in a trial or hearing. And you also have to prove, for example, that it has not been tampered with. It may be the phone, but if somebody wiped the phone, you can't rebuild the phone and say, oh, here it is, you know. So just something to think of. The reason or the way you can help with admissibility, it's called chain of custody. That means that when someone transfers something from one person to the next, one person must sign and say, I'm transferring this to you. And then you must sign saying, I agree to receive it and hold on to it and preserve it. Literally, it's called a chain of custody, and it's usually a written log. Let's go back to the old TV shows. Remember that place in the police department that had a big old cage, and people would walk up and say, hey, I need to see the gun that was used, and the guy behind the cage says, okay, sign here. You know, he pulls out this box of evidence, and the guy has to sign saying, you know, that I take custody of it. That's the chain of custody. And when somebody receives it, they have to certify that they are not going to tamper with it. They can examine it, but they can't remove parts of it, they can't erase parts of it, etc. It has to remain untouched or untampered with. So if you're looking at a gun, nobody can do something with the gun to change the nature of that gun or that bullet or that piece of paper, or in the case of what we're doing, those electronic records. Okay? You have to prove that it hasn't been tampered with. So here's my war story, and then we'll finish up. Here's my war story. I was working for the Secretary of Defense, and he had someone working for him who he brought in from industry having to do with something. I think it was related, well, I won't even share that, but brought in somebody who was working in the office, and he used to work for a corporation, but he was a retired military officer, and he used to complain that his laptop was running slowly. And so at one point, he agreed to have me come take a look at his laptop, and I said, yeah, it does indeed appear to be running slowly. Would you like me to clean it up? In other words, to refresh it? And he said, yes. So I took his laptop down to my office, and I was doing things like clearing cache, checking memory, etc., making sure that the OS was properly patched, etc. And as I was clearing cache from his browser, I encountered something that was absolutely, positively against the law. Absolutely. People go to jail for decades as a result of what I found. And I can remember I was sitting in the office at the time, people walking around behind me, and I found this. And I can remember I slammed my hands into the desk and pushed myself as far away from the laptop as I could and went, boss, and I never touched that laptop again. My boss came and took a look at it and said, oh, picked up the phone and called what's called the AFOSI, the Air Force Office of Special Investigations. And because we were an Air Force organization, and the AFOSI guys showed up, two guys in suits, and they took a look at it, and they signed a receipt that said, we received this. And this guy never went to court. This guy was never prosecuted. Now, he did disappear. He left the organization. He wasn't there anymore. But he was never subject to a court proceeding to try him for the criminal activities that it looked like he had been doing on this laptop, this government laptop. The reason is, I go back and surmise this, the reason is when I picked up his laptop, I did not sign a chain of custody form that says I agree to hold on to this and preserve it, etc. And therefore, there was no way to prove that he and he alone had been the person that had done this work, this stuff on his laptop. No way to prove it. The chain of custody was broken when I received the laptop and didn't sign for it. and didn't agree to preserve it. It was just a normal support activity. I said, I can take it down and clean it up and see if I can make it run faster. You know, I'm going to try and do some stuff, clearing cache and checking memory. And he said, okay. So there was no proof that would stand up in a court of law that this gentleman, I use that term loosely, that this person had committed these criminal acts with this laptop. There was no proof. There was no way they could prove it. They were there. It was his laptop. He was the one that used it every day, admittedly, but there was no way to prove that it hadn't been tampered with. Okay? Chain of custody is incredibly important for you in the course of any investigation. And if you cannot prove that a device has or data has not been tampered with, it's inadmissible. Remember that word, admissibility? Can't be used. You can look at it, everybody can say, nope, that proves that this guy did indeed, fire the shot that killed this person. Nope. Sorry. It's inadmissible as evidence. So just something to remember. Last but not least, does everybody understand the difference between conviction in a criminal court and a judgment in a civil court? Now, this is U.S. I'm not sure how it works in Finland, Kate. But in the U.S., there is conviction, but then there's also judgment. Can anybody tell me your understanding of the difference? Okay, I will share. Conviction means that evidence has proven and you have shown that some criminal act occurred and that this person committed that criminal act beyond reasonable doubt. That's like 98, 99% certainty that this person did this. However, if you're in a civil court, and let's say one person is suing another person about where their property line is, the difference is you do not have to prove something beyond reasonable doubt. You have to prove what's called a preponderance of evidence. And in its truest form, that is, you have evidence here, 50-50, but this one is 51% and this one's 49%. Judgment in a civil court can occur with just 51%. Okay? Very big difference. That's how we've seen this many times. O.J. Simpson, for example, he was acquitted of murder, and yet they took him to civil court and sued him for depriving these two victims of their human rights, i.e. the right to live, and a judgment was made against him for that. And the reason is the burden of proof is nowhere near as strong in a civil case as it is for a criminal case. The burden of proof is much lower. I just thought you guys would enjoy that one. That has nothing to do with IT. It's just my observance of the law. So, does anyone have any questions, any comments, anything to bring up before I finish the video? I hope you enjoyed this. I had fun putting it together.